knowledge session by Anivesh Legal Consultants. This session was supposed to be taken by me and Ayush, but Ayush is not available due to some work. So, I will be taking the session for today. So, just a second. Yes, now we can start. I think today we have a date of GST. It was 30th June. All of us were occupied in GST tribunal filing. So we were not able, we did not have enough time to prepare for the session. So we apologize for the skipping the last week's session. But from so first let so there is one Supreme Court judgment also, but that is not very relevant. So I'll take that in the end. So first we have the judgment of Shekhar Chandra Podar versus Union of India, given by Tirupati High Court. So this is again a very interesting judgment. So in this case, what happened is the uh, department issued show cause notice for the financial year 17-18 on July 2024. So as per department, the show cause time limit was within the time limitation period because GSTR 990 due date for financial year 17-18 was depending on the state. So department said that we have 5 years for the issuance of order. So that is February 2025. And for show cause, we have 6 months before order, which is August 2024. And the show cause notice was issued on July 2024. So as per department, they were within the time limitation period. No, assessor took a very good argument in this case that if you see the original due date for 17-18 GST and 990 was 31st December 2018. The government extended the taxpayers, they were not aware of GST, they were not aware of the new forms of 990, and as well as there were technical glitches on GST portal as well. So due to all these reasons, the taxpayer were not very familiar with the GST portal and forms, and that is why the due date was extended by the government from December 18 to Feb 20 for 990. But that was done only for the convenience of the assessee. Therefore, this extension benefit should not be given to the department. So for department, the time limit for order and show cause should be seen from the original due date of GST 990, which was December 18. According to December 18, the due date for order for under Section 74 expired on December 2023. Since show cause was issued after the time limit for show cause and order was already expired, the show cause itself is invalid as it is time barred. So, uh, although I personally disagree with this judgment because if we see a golden rule of interpretation, wherever the law is unambiguous, we have to go by the literal interpretation of the law. In law, it is clearly written that the order and show cause the timelines has been defined as 5 years from the due date of filing annual return, 4.5 year, 3 years from the due date of filing of annual return. So when the due date itself has been extended by the government, so in that case, in my view as well, the time limit for show cause notice and order also gets extended automatically. But nevertheless, this the High Court gave the judgment in favor of the assessee. Uh, I think it is a very, very good argument. So definitely, I am going to be taking this argument in other cases as well. So that was our first judgment. Then second judgment we have in the case of SKM Infra Venture by Odisha High Court. So this is again regarding one of the most common litigated issues, that is communication and service of order. So in this case, Odisha High Court held that service of notice or order through any of the modes given in Section 169 constitutes sufficient compliance. So even if the notice is uploaded on GST portal, it is sufficient compliance by the GST department, and it is on the assessee because he is a registered taxpayer. He has a login of GST portal, so it is on the assessee to log into that GST portal and check the notices and order. And assessee cannot be given any leeway on the ground that he did not check the GST portal. So in a lot of cases, we have gotten a lot of favorable judgments as well. Most of the judgments are given by Allahabad bench, Allahabad High Court. But as we can see, some of the high courts are also giving judgments in favor of the department as well, like this recent judgment of Odisha High Court. So as and apart from these two high courts, there are various other high courts. Some high courts, mostly high courts, have given in favor of the assessee, but there are two, three high courts who have given against assessee as well. So since we have two contradicting set of judgments from various high courts, so obviously the matter is going to go to Supreme Court. It has already gone to Supreme Court. So Supreme Court is already listening, hearing a bunch of petitions on this very particular matter. So let us wait for the judgment of the Supreme Court. Although in my view, a liberal view should be taken by the courts as well, considering that technology, the awareness level of the people in India. All these things also have to be considered in mind. So you cannot expect a population of what we are now 140 crore people. Out of that, I think almost 2, 3 crores are registered in GST. So the government cannot expect these 2, 3 crores people to be very well versed with GST portal and checking GST portal on a regular basis, and that also various other tabs. So for returns, you have a different tab. For notices, you have a different tab. Earlier, for additional notices, you used to have a different tab. So it is very difficult to expect from the assessee that he will either himself check the GST portal on a regular basis, or if it is a medium or a small businessman, then he will not even be able to afford a accountant or a chartered accountant or an advocate to check that portal on a regular basis. So all these things should be kept in mind by the courts while deciding this matter. Apart from the legal principles which are to be followed, I think this one very important practical reality should also be kept in mind. Then, moving on to the next judgment. So, this is by Madras High Court. I think Madras High Court has been very active in last 1.5 year. I've seen so many judgments of Madras High Court and so many quality judgments. The reasoning given in Madras High Court judgment, I am really fascinated by the grounds they take, by the arguments that is done before them, and the final judgments which is delivered by the Madras High Court. So again, this is a very, I would say, thought-provoking judgment. So in this case, Madras High Court, in the case of Fastenex Private Limited. So just a
Hello.
second.
Hello. Huh?
Yes,
Huh?
Ram Ramakumarji, you want to ask anything?
Huh.
Yes, sir.
ஒன்றும் பிரச்சனை இல்லை. அது ஏத்திக்கோ மெல்லமா. ஒன்றும்
I'm sorry, you must have been on unmute. So yes, so we were discussing about the Fastenex judgment. So in this judgment, the High Court focus. So when we read Section 74, it starts with the term that where it appears to the proper officer that there has been a short payment, short. excess availment, excess utilization, excess availment of refund due to fraud, willful misstatement, suppression, and so on, then he can issue a show cause notice. So the start of the section is where it appears to the proper officer. So the High Court interpreted the meaning of this phrase, where it appears. So the High Court held that this expression of where it appears, or it means that there should be a prima facie view. Obviously, this expression does not mean that there should be a conclusive view, but at least the proper officer should have a prima facie view that whatever short payment, etc., has been done, that is due to fraud, willful misstatement, or suppression. So, unless and until the proper officer has a prima facie reason for concluding that whatever the short payment has been done, that is due to fraud, fraudulent intention, section 74 cannot be invoked. So merely existence of fraud is not enough. At the time of issuance of show cause notice, the proper officer should have a prima facie reason. So let's say in a case where there is a clear cut fraud, but at the time of issuance of show cause notice, the proper officer did not have any proper prima facie reason to believe that this is due to a fraudulent reason, and he issued under 74 due to some XYZ other reason. Maybe because the time limit for 73 was already over. We have seen that in a lot of cases. This is a common practice by the department that wherever the practice under time limit under 73 is over, they blatantly issue under 74. So unless and until the officer has a prima facie reason that this is due to fraud, willful misstatement, or suppression, then 74 SCN cannot be issued. And such satisfaction of the proper officer, prima facie reason of the proper officer, that has to be explicitly in writing mentioned in the notice. Unless and until it is not written in the notice, it is not valid. Merely some impression, appearance, or assumption in mind of the proper officer cannot be construed as uh, prima facie reason. So I think this is the main issue of the judgment. The judgment then discuss some other aspects also, but those are very well settled law. So I am not going to go into that. There was another judgment by Madras High Court. So therein they also mentioned that even though where it appears means a prima facie satisfaction, but that is on a much lower pedestal as compared to reasons to believe. So, like in section 67, section 70, we have the term reasons to believe. So, that judgment held that reasons to believe that constitutes a very strong basis, very strong supporting document to have reason to believe, but as compared to reason to believe, where it appears stands on a much, I would say, lighter footing in terms of the evidence or the supporting a proper officer is required to have. But still, the proper officer has to have some prima facie reason to satisfy the term where it appears to the proper officer. Now, moving on to the next judgment. So next judgment we have in the case of Planet Automotive by Gujarat High Court in context of service tax. So in service tax, we had amnesty scheme in 2019 called Sabka Vishwas Legacy Dispute Resolution Scheme, SVLDRS. So, as per SVLDRS, in case any amount was quantified by the department or by the assessee during investigation, even prior to issuance of show cause notice, because once the show cause notice was issued, it was very clear that what is the amount of liability. So, basis that benefit was there, 30%, 40%, 50%. But that scheme also applied to cases where even during the investigation, some amount has been quantified. So in this case, what happened is that during investigation, the assessee voluntarily admitted some amount and paid some amount. Sorry, voluntarily admitted some amount, because if he had already paid, then any which case he would not have gotten the benefit. So the assessee admitted some liability, and basis that they filed the application under SVLDRS. So in this case, the court held that mere admission during investigation does not amount to quantification. So quantification means a conclusive activity. So this only covers the cases where the investigation has been concluded by the department, and there is some communication in writing to prove that this is the amount of duty quantified. So it may be pre-show cause notice, or it may be some other final audit report given by the department, or any other document issued by the department wherein they have quantified that this is the amount of duty which is payable according to us. So unless and until such document exists, it cannot be said that duty has been quantified, and until and unless that happens, the benefit of amnesty scheme under SVLDRS will not be eligible to the assessee. So in absence of that, any voluntarily payment made by the assessee during the investigation, that payment will not be eligible for the benefit of SVLDRS scheme. So next judgment, again a very very interesting judgment given in customs law in case of uh, Vidres India Ceramics Private Limited by Gujarat High Court. In this case, what happened is the customs department, they issued a show cause notice uh, regarding some classification matter. So they imported some goods and they reclassified it from pigments to printing ink. The show cause notice was issued, it was adjudicated, and order was also issued. After 1 year of passing of the order, the department issued a corrigendum to show cause notice, saying that with fresh allegation regarding valuation, that the goods imported by the assessee, that some other party also imported similar kind of goods. So some new evidence, this was a new evidence and documents which were introduced by the department by means of this corrigendum. So in this case, when the case went to High Court, so High Court held that even though if we see the relevant sections of customs, they say that after a show cause notice has been issued, the department has a right to amend, modify, or alter the show cause notice. But it has to be done prior to the adjudication of the show cause notice. In this case, the show cause notice was issued, the adjudication order was issued after 1 year from issuance of adjudication order. The customs department gave this corrigendum, substantially modifying the show cause notice, because the department introduced new facts, new allegation, new evidence, new documents. So it was not that some clerical error or arithmetical error was merely being rectified. That was not the case. The department tried to substantially modify the show cause notice by issuing this corrigendum 1 year after issuance of adjudication order, which is not allowed as per the customs law. So this was the decision of Gujarat High Court. So again, I'm discussing a lot of judgments today, but when I was going through the list, so many these interesting ratios I found in so many judgments. So I thought that I'll try to discuss all the judgments in brief today. And I think if any participant has any query related to any case law, they can just unmute themselves and ask the query as well. So next judgment again by Madras High Court in case of Guru and Company versus Union of India. So again, this is also a very, very interesting judgment. The government of India, central government, they made some changes in GST rate notification of goods. So mostly regarding these grains, so wheat, rice, and a lot of in for a lot of other food grains as well. Earlier, we used to have uh, rate structure wherein it was stated that if in case of a branded food grain product, the tax rate will be 5%. In case of unbranded, it will be exempt. The definition of the word brand name was that if it is so one of the criteria was if it is actionable claim, then it will be treated as a branded name, and accordingly the rate of 5% will apply. Later on, so I think this happened 2 3 years back. So 2 3 years back, the government amended the notification. So instead of the term actionable claim, they substituted it with the term enforceable right in a court of law, which is wider in scope. So a lot of cases which might not have qualified as actionable claim, but since they are enforceable in a court of law, so those cases also got covered in the term branded, and they also became liable for 5% GST rate. However, the problem is when the if we see the GST Council meeting, so this was decided in GST Council 21st meeting. So in GST Council 21st meeting, the GST Council only recommended the term actionable claim. But when government issued the notification, in notification they mentioned enforceable right in a court of law, which is wider in scope than the actionable claim. So the issue which went to the court is whether if we see Section 9 and Section 11, both of those mention that the rate or exemption will be such as given by central government on the recommendation of GST Council. So the notification under Section 9 and Section 11 they has to be issued on the recommendation of GST Council. So the question which went to the High Court is whether the central government is empowered to issue a notification which goes beyond the recommendation of GST Council. So in this case, the court clearly held that the government does not have the power because Section 9 and Section 11 is very, very clear. Whatever notifications has to be issued, they has to be issued as per the recommendation of GST Council, and the government cannot go beyond what is mentioned in the recommendation of GST Council. So if the GST Council has said actionable claim, only actionable claim has to be written in the notification. The government cannot go beyond that. So in this case, they struck down the notification to the extent it is ultra virus or beyond the scope of recommendation of GST Council. Another follow-up question which came is subsequently the GST Council ratified that use of the term enforceable in a court of law. So then the government argued that the GST Council had subsequently ratified the decision of the central government. So then also the decision of central government, the notification of central government should remain valid. So to this question, the court again answered no, because if we see the powers of GST Council as given in the Constitution, they only have the power to recommend whether recommend the rates, recommend the exemption. They do not have GST Council do not have the power to ratify the decision of the government as per Article 279A. So in that case, the any decision taken by central government without authority of GST Council, it that decision cannot be subsequently ratified by the GST Council. First, the GST Council has to make a recommendation. Only post that recommendation, the central government can take a decision. This is the correct flow of issuing any sort of notification, which has a similar language as Section 9 or Section 11. So in this case, the notification was held to be ultra virus to the extent it was beyond the recommendation of GST Council. Okay. So I think these were all the judgments of the High Court. We have one more judgment of Supreme Court. So that is our last judgment for the day. So uh, just second. Yes, sorry. So the judgment of the Supreme Court is again on the time barred appeals and communication and service of order. So in this case, the assessee did not. So the order was uploaded very early. The assessee did not see the order on GST portal. They saw the GST order on GST portal for the first time in 2024. And they approached High Court in 2025. So almost 1 year after they saw the earlier order, saw the sorry, almost 1 year after they saw the order for the first time on GST portal. The High Court rejected the petition of the assessee, and against that the High Court order, the assessee went to the Supreme Court. So in Supreme Court, the Supreme Court gave two reasons. First, that merely this argument that assessee does not have petitioner or assessee does not did not check the GST portal, that merely on these ground the benefit should not be given to the assessee. And even if that benefit should be given, in this particular case, the assessee, even after checking the GST portal in 2024, and when the assessee got to know in 2024, still they took almost 1 year in filing the writ petition before the High Court. So, because of this reason, the Supreme Court affirmed the order of the High Court. But the Supreme Court clearly held that this in this case the factual matter is different. So in other bunch of petitions, the High Court some bunch of petition is pending before the Supreme Court on this particular issue only, whether the service or communication of order merely through GST portal should suffice. So Supreme Court held that the factual facts of the case is different from that bunch of petition. So that is why this decision was separately decided by the Supreme Court. So I think merely because the relief was not given by Supreme Court in this case, this should not be taken as a precedent. Because in this case, the assessee, even after getting to know about the order, even after that, they took a complete whole year in approaching the High Court. So in case where the assessee, even though they belatedly got to know about order on GST portal, but immediately thereafter they took a action by filing appeal or by going to High Court. In those cases, I think this case law will not apply as this case law will stand on a different footing. And for that other category of case, the bunch of petitions which are being heard in Supreme Court right now, they should be the ratio deciding. So I think these were all the judgments we had for today. As regards the legal update, so I think most important legal update, as we all must be knowing, was the extension of due date for filing appeal before GST tribunal. So for earlier, for any order uh, passed up to 31st March 2026, the due date to file appeal before the GST appellate tribunal was 30th June 2026, which has now been extended to 31st July 2026. So again, I will repeat, for any order passed up to 31st March 2026, the due date will be 31st July 2026. And for any order passed after March 26. So any order passed from 1st April 2026, the time limit will be 3 months plus condonation period. So I think condonation period will also apply in this case. So the time limit of 31st July, that is without the condonation period. After 31st July also you can file along with a condonation application and giving a reason for delay in filing the appeal. I think that was the major update we had during the last 2 weeks. So now we can open the floor for any questions, queries of the participants if they have. So any participants have any query they want to discuss? So first question is by Akshat Agarwal ji. How much time GST will take to finalize the case filed before them, keeping in view the pendency of the cases? As my case belong to LKO bench of GST. So sir, I'm assuming by LKO you mean Lucknow bench. So, Lucknow bench of GST, till now there is no communication from registry on regularization or defect of cases. I would like to know your view, sir. So, Akshatji, to my knowledge, till now hearings have not been started by any bench except the principal bench of Delhi. So only because the judgments we are seeing right now, we are only seeing the judgments by principal bench. So apart from principal bench, the other benches they are in the still in the process of setting up and no just completing the process of this. appeal, filing, hearing, and all these processes. So actual hearing has not started yet. So I even went to Lucknow a few days back for the for some program. So there I met the judicial member, presiding judicial member of the Lucknow bench. So they are in a very active stage of preparation, that I can tell you. But as regards the actual date of commencement of hearing, so I believe that should take at least 1 to 2 months more. So maybe around August, September, we will start to see at least major benches. So Bombay, Bangalore, Chennai, Lucknow, Noida, Gurgaon, these major benches, at least they should start functioning in next 1 to 2 months. And by end of 2026, hopefully at least 70 to 80% of the benches should start their operations. But so this is just an conjecture on my part. So no official communication has been given by the department. And even after the cases are started, hearings of the cases are started. The your case number. So uh, in that complete queue of the cases before the tribunal, how further is your case? That is going to have a major impact. So in current CSTAT also, we are saying that there is a average delay of 6 to 7 years. So today in 2026, most of the CSTAT benches are hearing cases of 2019, 2020. And considering that GST will have a backlog of almost 9 years when it starts. So I believe that average period of 2, 3 years, 4 years is going to be very normal in disposal of the case. Then next question is by Shweta Agarwal ji. Uh, For communication and service matter, should we opt for GST 80 route or for the High Court route, where the allegation is regarding 3B, 2A versus 3B, and no genuine access claim? Currently, the first appeal proceeding are pending from the department. So, Shweta ji, one thing I would like to clarify from you. So the first appeal has been filed within the time limit of the due date of upload of GST portal. So within that time limit, the first appeal has been filed, or the first appeal is time barred, or it was delayed filing. Okay. So I think this is a very interesting question. I have had discussion with a lot of people on this particular question. So, see, in my view, the issue is if there is a delayed filing of appeal, and delays beyond 1 month, which is the allowable condonation period given to the department authorities. So, in my view, GST 80 does not have the power to condone the delay beyond 30 days. That we have to be very clear, because GST 80 is the creature of the statute, so it cannot go beyond the GST law. But when we say that the time limit for filing of GST appeal is 3 months from the service of the order. So what is the meaning of service of the order? So let's say we have a judgment of Allahabad High Court today, which says that if the order has been uploaded on GST portal in, let's say, in 2024, but the assessee saw the order in 2026, then the date of effective communication will be 2026. Therefore, the date of service will also be 2026, and 3 months should be seen from that date when the assessee saw the order for the first time on GST portal. So, in that case, this is an interpretation of law. The High Court is not going beyond the uh, GST law, even though High Court has the power to do so under Article 226. But the High Court has not gone beyond the GST law. It has merely interpreted the provision of GST law regarding service of notice and service of order and communication of order. So I believe the GST tribunal also has the same power. So in conclusion, if you are arguing that the date of communication of order, date of service of order is was delayed due to any reason, the assessee saw the order late, the assessee did not see the order, or whatever reason. if the as a consultant, as a counsel, you are arguing that the date of communication is not the date when it was uploaded on GST portal, and it is actually delayed, and within 3 months or 3 plus 1 months from the date of actual or effective communication of order, you have filed the appeal. Therefore, it should not be time barred. So for this ground, I believe you can go to the tribunal, where you are not taking this ground, or you are saying that, and you are saying that there is an actual delay beyond 4 months. Then you should go to High Court, because in that case, only High Court has the power to condone the delay before beyond 4 months. The next question is by Akshat Agarwal ji. What will be the binding precedent of GST-80 orders, particularly on any decision involving a question of law? So, Akshay, GST-80 will have jurisdictional, so like any court, uh, in the jurisdiction where the GST-80 is there. So, in its jurisdiction, all the order of GST-80 will be binding. So, for Lucknow bench, whatever area is governed by the Lucknow bench of GST-80, the officers coming in all those areas of GST-80 bench, either the center or the state officers, they will be bound by the orders of GST-80 on question of law. Then next is Darshil ji. I believe the due date of GST 80 31st July is for OIA till May 1. So Darshil ji, I will check this once, and maybe I'll check this. If there is any change in my earlier statement, I will discuss in the next session. Next, again by Akshat Agarwal ji. They have created a special bench on time barred issues. Further hearing on such cases due on 20th July. Is they have any authority to condone any delay under 1074? So by they, do you mean Supreme Court? Akshayji, yes. Hello. Akshayji, I'm not able to hear anything. So Akshayji, my question was, जो आपने इसमें लिखा है, they have any authority. So what do you mean by they? Do you mean GST officer, GST tribunal, or High Court, Supreme Court? GST-80. So actually, like I said, GST-80 does not have the power to condone the delay beyond the 4 months. But GST Tribunal has the power to interpret the meaning of date of service of order. So GST Tribunal. So again, I'm taking a hypothetical example that so let's say Delhi bench of GST-80, they can very well give an order that according to us, the date of service of order should be the date when the assessee got to know about the order on GST portal, and not the date it was uploaded on GST portal. So this judgment, in my view, can be given by the GST-80, but GST-80 cannot give this judgment that the delay is beyond 4 months and we condone the delay beyond 4 months. That power is only with the High Court, but GST-80 can very well give a judgment saying that the date of service of order should be interpreted to mean so and so. And if the appeal is filed within within the applicable time period from the date of service of order as held by the GST-80, then the appeal should be considered within time limit. Okay, the principal bench has a hearing. So I think this is because this condonation of delay and meaning of date of communication in service of order. So this is one of the biggest litigation area we have seen in last 1 to 2 years. And with GST 80 bench coming into picture, I think this is one of the first issues they wanted to address, so that all the benches can follow the settled precedent accordingly. So let us wait for the decision of the GST 80 bench. Thank you, Aksharji, for your kind words. Any other query of any participant? So I think all the participants have asked their queries. So thank you so much, everyone, for attending today's session, and hope to see you all in the next session on next Saturday. So thank you, everyone. Let us conclude for today.